Hello everyone, we're gonna start this panel. So we are very happy that you all decided to stay with us today to discuss about a very interesting and closely related topic to the one you just discussed about. We're gonna talk about global legal fragmentation and interoperability. So concretely today, we're gonna illustrate this fragmentation by focusing on different legal privacy and data protection frameworks in Europe, but also in Latin America, in Asia, or in the United States. This panel will address the resulting risks that such fragmentation could entail, including for innovation and economic development, and we'll try to outline global solutions such as adequacy findings, as you just discussed, or certification mechanisms. But let me have the honor to introduce our moderator and our panelists of today. So here you have Hilary Wandall, who is a lawyer, scientist, and ethicist, and is currently General Counsel and Chief Data Governance Officer at TrustArc. She leads the team responsible for designing and developing the company's privacy content and intelligence products, including its certification program and technology solutions. Then you have Michael Rose, who is the lead advisor at the Department of Commerce for cross-border privacy rules system and global data privacy initiatives. He leads work in the G7 and G20 on ICT, e-commerce, and digital trade policies, including cybersecurity, privacy, and emerging technologies. Michael also leads policy engagement in the Asia-Pacific, Oceania, and South Asia, including India. He also serves as the vice chair for the APEC data privacy subgroup, and is a former presidential management fellow, having worked in the US Congress and in the White House. Then you have Bruno, but you already know him from the last panel. We also have the pleasure to have BrianN Nougre with us, who's a lawyer who works for the Uruguayan Parliament. She's also a teacher of data protection and legal informatics at the School of Engineering of the University of Montevideo and at the School of Law of the Public Uruguayan University. She's also the director of the Privacy and Data Protection branch at the Estudio Jurídico BrianN and associates in Uruguay. We also have Mac Yokozawa, who is the head professor of the Market and Organization Informatics System Laboratory at the Graduate School of Informatics at Kyoto University. He is leading bilateral, regional, and multilateral discussions for digital economy policies, and also bilateral dialogues with the US, the EU, Korea, Taiwan, India, and China. And lastly, Amba, who is currently public policy advisor at Mozilla. She's responsible for developing Mozilla's policy positions for the South Asian region. Prior to Mozilla, she worked as legal advisor to the Indian communication regulator, focusing on network neutrality and competition regulation. She's also a former Google Policy Fellow and a Rhodes Scholar. So maybe I will first leave the floor to Michael to introduce our topic.
Thank you, and thanks for sticking around late. I am very glad to be here. As many of you are likely aware, the US government had a very prolonged period of not doing anything. I had 35 days at home and annoyed my whole family. Nothing works for me. So I know, they were just stop talking. And so I found out I was coming here at 6 a.m. on Monday for my 10 a.m. flight. And then I drove through a blizzard in Colorado to get here and got here for a blizzard. So I'm very happy to be here today talking about privacy. It's pretty obvious why the government gave me 4 hours to get here. If you just look at the sponsors on our bag, it's like 98% American companies. Privacy is a huge issue in our country, even though we don't have a domestic privacy law. My companies care distinctly about complying with GDPR. They care distinctly about complying with Japanese or Korean law and around the world. And what we're hearing and seeing is a global trend, not just towards privacy laws, but privacy laws that all look and feel a bit similar, but have distinct differences that make them fundamentally incompatible without tweaks or alignment. You look at, and I won't jump the panel here, but the recent EU-Japan mutual adequacy finding required 5 supplementary rules by Japan, and I think the APPI and GDPR are very similar when you get down to the nuts and bolts of what they're both attempting to do, and they still required some supplementary disciplines to bridge the gaps. So that's a problem not just companies are facing, but policymakers in looking at an ever more disjointed and fragmented digital economy. My team at the Department of Commerce is trying to lead the way in bridging these gaps through certification mechanisms that allow for data to move, stimulate innovation, and not restrict emerging technologies such as artificial intelligence, blockchain, and other as yet unforeseen technological advancements that you all in the academic, legal, and policy spaces do at companies. So primarily the US supports 2 certification-based systems with our regional trading partners to facilitate data flows and privacy protective practices. The United States has worked with industry, other governments to facilitate the OECD privacy framework, the APEC privacy guidelines, the privacy protective practices at our companies through the Safe Harbor and then the Privacy Shield certifications. And we believe that recognizing enforceable certifications and codes of conduct in domestic laws, as Japan, Brazil, and others have done, could allow for existing enforceable certifications like the cross-border privacy rules system, like the EU-US Privacy Shield, to ensure interoperability between differing privacy regimes beyond other mechanisms at use in the global policy space, such as adequacy findings or trade agreements. We believe that company-based certifications present a practical and quick solution to this growing problem. As I said, the EU-US Privacy Shield is an example of a certification program that enables different privacy approaches to work together to support cross-border data flows. We are very grateful and happy for the joint showing at the 2nd annual review from both transatlantic partners. There's over 4,300 companies that have made enforceable commitments to the Privacy Shield in the United States. And we're very grateful that the administration announced the nomination of the official ombudsperson just in the last week to hold the undersecretary position at the State Department to further our commitment to the Privacy Shield. But beyond that specific transatlantic initiative, we have the cross-border privacy rules certification with 9 APEC partners. The CBPR system was developed from baseline principles that have guided the GDPR and global privacy practices, such as the OECD guidelines and the APEC privacy framework. TrustArc, which my good colleague Hilary works at, is a leading privacy and certification company, and is calculated that roughly 90%, there's a roughly 90% consistency between CBPRs and GDPR. They're very similar. While they ultimately have key differences that need to be bridged and gaps that need to be addressed, they're a foundation for transfers. CBPR uses enforceable certifications that are binding by both the third-party certifier and the backstop enforcement authorities. They allow for extraterritorial enforcement through a network of enforcement authorities that work in conjunction should a case be brought. So if you are a Japanese consumer and you have an issue in the United States and or Korea, the FTC, the PPC, and the 2 backstop regulatory enforcement entities in Korea can work together to take joint enforcement actions. It's a unique model. It's a unique system that has been used before for historic actions, such as in the Ashley Madison case, where the US, Canada, Australia, and New Zealand took a joint enforcement action for privacy violations. The CBPR system also requires binding commitments for your third-party onward transfers, as well as an ultimate reliance on domestic law. So if you have a CBPR certification and you're a CBPR certified company or country, as Japan and the United States are, you're not exempt from complying with US or Japanese law. It's a baseline for transfers that creates a harmonized internal infrastructure for your companies. But if you have additional rules or additional requirements, such as HIPAA, our healthcare law, our healthcare privacy law in the United States, you aren't exempt from complying with it just because you have a CBPR certification. So it's really meant to create a foundational system that can then be regulated and jointly enforced across regulators. So these are the general issues that we see growing up from the US Department of Commerce and the US policy space, is bridging these gaps. We feel that certifications are the most efficient way of doing it. You know, I think we've all seen and noticed how long negotiations can take. You know, from the Privacy Shield perspective, negotiating a system like that and maintaining it is an incredibly laborious and challenging process. It's a rewarding one, but certifications themselves can be and have been used for 15 years as a trusted way of transferring data. So that's the US's approach to bridging this regulatory fragmentation that we've seen. So I'm gonna pause there.
Okay. Hello again, everybody. Well, I will surprise you. I don't think that when we talk about privacy, this is a word of fragmentation. So I fundamentally disagree with the panel to which I'm participating. The jokes apart. If we look at the situation now compared to the situation a few years ago, I'm using, but then telling me it's working. Is it working? No. So. So that seems to work. So I will start again because that was my the only interesting thing I'm going to say. So I will surprise you because indeed I don't think that this is a work of fragmentation. If we compare the situation today with the situation even a few years ago, the amount and the trends towards convergence we're seeing is extraordinary. Not only in terms, and this is not only, this is not so much a quantitative question, how many laws, how many privacy laws there are around the world. This is a qualitative development, that those privacy laws tend more and more to be based on a common set of principles. We don't need identity. We just need that there is, those commonalities are in place to ensure that required level of protection and also to facilitate transfer. And that's the solution. Long-lasting solution for transfers, for ensuring the trust of consumers, for ensuring the stabilities of data flows, need to be rooted in national legislation, in binding legislation, which have sufficient teeth, needs to be backed by robust enforcement. And that's what the Japanese mutual adequacy is an example of that, but we can find many other examples around the world. So certification mechanisms, they also exist in EU law, but they might be helpful to demonstrate compliance, to help companies demonstrating compliance, but in themselves, they cannot provide for that type of protection, enforcement, exercise of individual rights. When we are talking about a human right, a fundamental right, of course, that point is fundamental. So we are looking with interest, of course, at the CBPR experience because it's an experience that brings a lot of different countries in that area of the world together, countries with no legislation at all, countries with much more developed legislation in the field of privacy. But as such, from an EU point of view, let's say immediately, because I've hearing we are at the end of the day, the moment of for a clear message has come. those who are selling the mutual recognition or the automatic recognition or using CBPRs as a way to show compliance with GDPR are selling something that doesn't exist. And we have to be very clear on this. We would be very happy, and we have participated to meetings in the context of the APEC to work with APEC to see if there are ways to reinforce those standards. I respectfully disagree with what I've just heard about the 90% or 99% of commonality between the GDPR and the CBPR. Maybe, yes, in terms of headlines, you have a principle in terms of purpose limitation. But that's not sufficient to base on that specific rules, enforceable rights, and so on. So that's what I can say at this stage. I don't want to take more time. But again, this is not at all a negative message. First, because that convergence and that long-lasting convergence is taking place as we speak. And then I'm sure with many partners, including with APEC, there are ways to bring our system closer and build those bridges that we indeed need. Thank you.
Hi, is it working? Yeah? Good afternoon. I'm going to speak from the point of view of Latin America, and I'm going to speak on 3 stages in the evolution of Latin America during this century in what has to do with data protection systems. So the first stage is the stage in which the 20th century is finishing. There was no express, that's it. Do you want me to pass it or? Where is it? Here? Oh. Sorry. Okay, thank you. Well, let's forget about it. Well, I mean, the first stage is a stage in which there is no express recognition for the right of data protection. Most countries provide a constitutional protection for the right to privacy, and some constitutions provide means of enforcement, such as habeas data. There are no general laws on data protection, with the exception of Chile and Argentina, but there is a common background of laws and regulations that consider data protection as a right inherent to human condition or that derives from the republican form of government. In what concerns to international instruments, good, thank you. That is the constitutions, that's the law. International instruments, well, it's the same. We have everywhere. And then we have 2 sectoral laws in health, genetics, statistics, children, credit records, or professional confidentiality. So that would be the first stage. Then we come to the second stage. I'm going to go a bit in a hurry. You have the data in the PPT. The second stage is a stage also of defragmentation. I mean, there is no fragmentation. In the first stage, it's very similar. All Latin America go in the same direction. In this second stage, the same is what we can observe, because all Latin America is going towards the European Union data protection system. I believe there are 3 milestones that marked this stage. The first one was the declaration of at the summit of the heads of state and government in Santa Cruz de la Sierra in November 2003, in which it was established the importance of the right of data protection as a fundamental right and highlighted the importance of regulation in Iberoamerica to protect the privacy of the citizens. Then there was the second milestone, which was the declaration of Antigua Guatemala at the first Ibero-American meeting on data protection 2003, in which the Ibero-American network was created. It gets more profound in the same terms of the other one. The third milestone, I believe, is the declaration of Cartagena de Indias in 2004, made by the Ibero-American Network of Data Protection, in which the informative role of the Ibero-American Network useful to understand how the data protection system operated in each country, and it is decided that that network should assume a more proactive attitude looking for concrete achievements. Two roles are marked for this network. The first one is the exchange of information regarding laws, bills, jurisprudence, events based on reliable, current, and relevant information, permanent advice on mutual assistance related to bills or specific practical issues, and cooperation in the creation of documents and common proposals, such as referring to access, DPAs, or standards. What happened next? We could see that when you study the laws in the countries. The milestones gave us this. There were quite a lot of laws in data protection following the European system. Argentina is in 2000, but then there was Uruguay, Mexico, Peru, Costa Rica, Nicaragua, Colombia, República Dominicana, and Brazil. And we have bills too in Chile and in Panama that may be approved anytime, any moment, and there's another bill in Ecuador. From these countries, only Argentina and Uruguay were declared as countries with an adequate level of data protection according to Directive 95/46 by the Europe and the Council, and Uruguay also ratified Convention 108 in 2013, becoming thus the 45th state to become a party of Convention 108 and the first non-European country to do so. Nowadays, last year in 2018, also Mexico and Argentina ratified the convention. So, third stage. I thought I talked about first and second stages in which there was no fragmentation. Now, I believe in this third stage, we can see some elements that makes us think on fragmentation. What happens? Several countries are assuming different positions. I mean, in what concerns to Peru, there was a law, an act that regulated the fundamental right of data protection and the DPA following the European data protection system. But in 2017, that changed. And it was approved, it was created a National Authority of Transparency and Access to Public Information. The idea of that creation was to strengthen data protection regime, but in fact, what happened is that the DPA came to be part of that National Authority of Transparency and Access, changing what we think is more appropriate, that both have the same level institutionally. This process came on, and there was a legislative decree, and nowadays there is an authority in access that is going to, there's a bill that has been studying at this moment, which states that the Court for Transparency and Access to Public Information will attend data protection affairs. So that is Peru. When we think of Argentina, we also used to have a law following the principles of the European regime, and we also have the adequacy. But this is changing a bit. A very modernized bill on data protection is being studied at the Congress. It's a very good bill. It's a good one. It might be approved at any moment. But it's been studied for a couple of years. And in the meantime, 2 years ago, the DPA changed its institutional location. And once more, it became part of the ministry, of the Agency of Access to Public Information, depending of President Macri. You see, there's not the same rank in both access and data protection. There's also one more comment, that is that the legal instrument to determine this change is what in Argentina is called a decree of urgency and need. And it's been studied and it's been very criticized because nobody understands quite well which is the urgency or the need to change this. What happened in Brazil? We had the law that was approved in August last year, following the principles of the European system. And, it provides legal network, and okay, that's all the same. Same model. The majority of its articles will come into force in 2020. There was a formal problem with the DPA that was solved, and in the last days of December, the DPA was created by Presidente Temer. Other example of what I'm calling fragmentation is Uruguay. Uruguay, has a general law that was approved 10, 11 years ago. There was the Declaration of Adequacy, and then there was the ratification of Convention 108. But Uruguay is having a different attitude, because in the last year, there was an act that approved rules for the adaptation of the Uruguayan data protection system to the GDPR that came into effect on the 1st of January this year. So in this moment, I saw, we had defragmentation, and now we are seeing fragmentation. And I thought, like Alice and Wandall said, how puzzling all these changes are. I'm never sure what I'm going to be from one minute to another. So, how to bridge this divide? Many things can be done, but I'm thinking just in a couple. A good idea is to work at the generation of a culture on data protection. The certification, even dual, is a good idea too. Software and interoperability are good ideas too. I tend to think that perhaps we have to wait for that a bit. But what I do know that is important and has to be done immediately is to assume sorry. What I want to say is that in all chaos, there is a cosmos, and in all disorder, there is a secret order. I hope that we can find that secret order as soon as possible. Thank you.
So is it me?
I think so.
Okay, so just bring my slides, please. Okay, so my name is Yokozawa from Japan, and just I working as the university professor, and the as a private sector, I have a pretty much experience to talk with Mr. Bruno Giancarelli and the Michael Rhodes in many cases. Yes, so just let my start, and I should be brief. So, just a little bit apart from the privacy protection, I am just showing the internet fragmentation. So, and not all the reason is only the personal data protection, but in some cases, and another part of the fragmentation is happening around China. So many of the American companies and even the Japanese companies are shut out from the Chinese market. And it's something between the US and EU. So the Daily News and the Chicago Tribune and the Orange Sentinel, so many news sites in the US are blocking the access from the EU because of they want to follow the GDPR requirements. So, this is some sort of the internet fragmentation caused by the privacy rule fragmentation. So, sorry, but this character is just too small. But I wanted to say that the Japan, EU, US, and China and Asian countries, the comparison and the privacy, personal data protection rules that are actually fragmented. So Bruno Giancarelli is right. So it is not a fragmentation, might be, but they are all originate from a single concept that we should protect the personal data. So the OECD guideline in 1980 is a very good example of the common concept of the personal data protection. So now Japan has the two harmonization to the two. Okay, that's okay. So two different regions. One is, of course, EU. We have talked about the adequacy, mutual adequacy recognition between with EU. And we have the CBPR certification led by the APEC DPS, data protection subgroups. And Japan is the second country, second economy, to have the accountability agent for the CBPR. But we have, don't forget the other countries like China, Brazil. I have learned from your talk about how the Brazil is complying with the GDPR, or India, Russia, and the Middle East and North Africa. So so many countries have a little bit different implementation or enforcement of the personal data protection rules. Okay, so what is happening now? So in this month, in WEF, World Economic Forum in Davos, Prime Minister Abe of Japan has proposed DFFT, which is a data free flow with trust. And this is not limited to the personal data, or the industry data and the business data and public data were well included in this concept. So Mr. Abe, Prime Minister Abe just proposed that there should be some free zone, free transfer zones in the global scale. So that will help the data economy, digital economy to grow up faster than ever. And the last month or last year, at the end of the last year, we have Japan internally talked about how we can achieve this goal. And our idea was firstly, Japan, US, and the EU will begin this free trade zone, free data flow zone. So this is an example of how much we need the harmonization and interoperability of the different implementation of the personal data protection, or even the data protection in many meaning. So yes, the CBPR and GDPR, I would like to stress that this is not a competing concept. Okay, so Japan is following GDPR and also the CBPR. So regarding the CBPR, we have 3 companies in Japan who has successfully certificated by the accountability agent in Japan. One is the Intersect company, and they have some branding effect from the certification. So they have a very good reputation in personal data protection in APEC area, or not even limited to the APEC area. So the second company is very interesting. That is called GMO, Global Sign Company. And they stated that that acquiring the CBPR certification is the beginning of the comply to the GDPR system. Okay, that is a very good entrance system to learn about how we can protect the personal data. And the third company, that is the financial payment company, Paydi. They see the actual practical effect from the CBPR certification. So the things is moving, practically moving. So we can expand this movement and inside the CBPR certification system. And the next step should be how we can liberalize the CBPR and the GDPR in the sense that the higher level of the personal data protection should take place in the Asian area. So, Okay, so I will skipping this slide. So this is how private sector, including myself, and the public sector in Japan, PPC, are collaborating in the acquisition process of the GDPR adequacy. So I am working with some associations, JETA and JISA, both Japanese associations. Here, Professor Simpo has stressed that there was a very good collaboration between private and public sector in the EU-Japan negotiation process. Okay, so yes, what are the gaps? This is very good, just a food for thought. And I just stated GDPR, APEC privacy frameworks are not competing concept. And GDPR and APEC frameworks both originate based on the OECD privacy guidelines. So happy to tell that we have the OECD electoral. And we are beginning as the next review process of the 1980 OECD guidelines. And maybe this should be a very good chance for us to think about it, how the guidelines or common concept in the privacy protection can go one step forward to the international harmonization or global anti-fragmentation of the privacy protection systems. Okay. So, and from the Japan's view, what are specific in GDPR is so that is also already stated by the many speakers here. It's based on the fundamental individual rights, and the GDPR is governmental regulation, and the CBPR or APEC frameworks co-regulation or self-regulation process. So it is very different. So CBPR is never a legislation. And the GDPR is not an ex-ante regulation, but sometimes being misunderstood, at least in the Japanese countries. So and companies. So in GDPR, GDPR is well recognized the risk-based approach and balanced approach and flexible approach. And the GDPR is scoping the digital single market. So Japan can be sold as the secondary digital single market of the EU. So that's I just wanted to say that this is a very good opportunity for Japanese companies to use the EU-based cloud services or AI or many advanced technologies developed in the EU. So we can export the Japanese citizens' data to Europe. So that's a mutual recognition system. So we sometimes we tend to forget this effect. Okay, so I will be skipping some of this. And the next step, so the combining the certification mechanism and national privacy regulation is very important things to do. And interoperate different certification mechanisms, namely a CBPR and the European certification as the next step. And encourage business sector, including the SMEs, with benefit of industrial certification is very important. And the communication and collaboration in public-private, region to region, and forum to forum, it's very, very important. So this is what we have learned from the GDPR recognition process. Thank you very much.
Thank you for listening so far, and I beg your patience for just one, well, not one last, but at least as the last speaker, I will try and be brief and, if possible, entertaining. So yeah, I'm Amba, I work for Mozilla. So a few words on Mozilla. So Mozilla is most famously known as the creators of Firefox, the open source browser. We are a mission-driven company, but these days everyone is a mission-driven company. We're different because we are bound by our mission in a special way. We are fully owned by a not-for-profit foundation. So in a sense, we are really constituted by this mission. Principle 4 of our manifesto states that individual security security and privacy on the internet is fundamental and cannot be treated as optional. It's why we are advocating and have advocated for strong baseline data protection laws across the world. Here in Europe, we've supported the GDPR. In India, we are currently supporting strong data protection norms, also in Brazil, as well as in Kenya and at the regional effort at the African Union. So I'm going to start by I'm going to make 3 broad points. The first is maybe in line with what Bruno said, is to push back a little bit against the framing of fragmentation as the problem, and instead say why the incentives for convergence with the GDPR in India has had a very positive impact on national developments. I'm taking India as a case study, but I think some of these learnings are applicable to other countries as well. Then secondly, I will move to where I do see cracks in the consensus, so maybe to speak to where there might be fragmentation and what are the ways to resolve that. And related is, I'll say a few words on, a few remarks on certification as a potential solution, as some of the panelists have proposed. So to start with on convergence, and I'm going to talk, like I said, I'm going to focus on India. It's interesting because if you look at the debate that's panned out in the last year or two in India, we often talk of the GDPR as we want it to be the floor, not the ceiling. And why that's important is because the floor, even if it is the floor, and even if that's what we get, it's still a pretty high floor. It's still a pretty high bar. And so that's reassuring that if GDPR is the floor for countries that are contemplating data protection laws in their own countries, it's still a pretty high standard that they're trying to meet. But the more interesting question is that where have these incentives come from? And it's interesting because, as you know, usually we would assume that we'd be the only tech company in the room saying that we want strong data protection, but in fact we weren't alone in India. We saw that large parts of the IT industry were also very supportive of having strong data protection norms and not lobbying against it. And one of the main reasons for that is that they saw a trade opportunity. They saw that, and Japan has beaten us to it, but they saw India and EU together as possibly one of the largest addressable markets in the world with free flow of data between them. So I think that was in a way a kind of positive driver just to get the incentives on the floor and to kind of set the ball rolling. And then the second order point, which is more pragmatic, is that when a country is faced with a mandate, say in India it was pass a data protection, the Supreme Court, literally told the government, you cannot have a biometric ID system without a data protection law. So, go ahead and pass a data protection law. So they're on a deadline, they're on kind of time constraints, and they're looking to other countries that have thought about this issue for years, maybe even decades. And so in that sense too, GDPR as a text and the data protection directive before that is a text that has been in the public domain for a long time. And so people might disagree with it, but that is the reason that many see, I think there was a panel today called copy-paste, but many people do see strong textual influences of the GDPR in the Indian Data Protection Bill and also in Brazil. So I think just to put a finer point on what are the substantive provisions where we see convergence before I move to fragmentations, I think first is strong obligations on both the private sector and the state. So this is your purpose limitation, collection limitation, storage limitation. These are principles which go far back to the FIPPs and from the US as well, but they are solid and we can be guaranteed that we think that those are the parts of the bill that will definitely pass. The second, which is again has a strong GDPR flavor, is the grounds of processing. So the Indian Data Protection Bill also says that every single act of data processing has to be justified under one of a certain number of grounds, and that's in some senses quite similar to GDPR and other GDPR-like laws. The third is rights. So there is a bundle of rights in the Indian Data Protection Bill. And finally, the enforcement mechanism. I'll come back to why this is a more tricky one, but broadly the idea that you have to have an independent regulator that is backed with strong punitive powers. Otherwise, it's not going to work. So yeah, just to go back to my original point, I think for Mozilla as a company, but also for a lot of other small, medium-sized Indian businesses that are looking to go global, it's it often makes sense to comply with this higher standard. You might call it a GDPR-like standard or a general global high standard of data protection, because it kind of immunizes you from the risk of tomorrow another data protection law is being passed in one of our markets. Do we comply? So I think that's something which, that kind of internalizing that thinking within companies has been a really positive impact of convergence. So now I would say now coming to where it gets tricky on fragmentation. In India, I'd say the main one which has stuck out like a sore thumb is on the blanket mandate for data localization in the draft bill. So unlike, some people kind of blur this and say this is like borrowing from the GDPR, but it's actually very different. So it's a blanket mandate that all personal data must be stored on servers within the country. The reason that this has been highly controversial is because it's not based, it's kind of, unlike the GDPR, it's not saying that we're going to limit cross-border flows in the interests of protecting the privacy of residents. It's kind of putting a blanket requirement. But more importantly, the two big reasons given for it are law enforcement access to data and the access to this data from Indian industry. So again, we're wondering, is individual privacy and security really at the heart of this proposal or not? There may be good arguments to be made and we're open to them, but we don't think that that conversation has been had. So that's one. And the second is on the independence of the regulator. I was watching a panel earlier today where somebody said that the idea of an independent regulator regulating the government is just not an Asian concept. And I would be really worried if we accepted that as a proposition, because in fact in India we do have examples of strong and independent regulators in the financial sector. And so it is true that the current draft needs more legal safeguards to ensure independence, but it's another example of where we do need to push, and where often the arguments that we use are that you won't get adequacy if you don't have an independent regulator, and that's something that can be persuasive to government. So to the point of what can fix, say, the specific kind of fragmentation, where we can get to certification in a bit, but I don't know if certification would solve really this problem of, for example, a data localization mandate in an otherwise robust and GDPR-like bill. So that's I think a question to be debated. Now, on certification in particular, I think our view has always been that it is really important to have a strong overall overarching data protection framework. Within that framework, you have to give companies flexibility and a variety of options, a bouquet of options, whether that's binding corporate rules, model contractual clauses, adequacy for countries or sectors. So these are all options which are and should be available to companies. But where we might be concerned is in the absence of such a baseline law. If you are going to put in place certification mechanisms, then the question is going to be, is this certification robust? So we're looking at this debate about the APEC CBPR, and earlier today the representative who's here, Raul, was mentioning that they don't think that that certification is robust, and so that is the reason why it isn't being accepted on its own as being acceptable. So I think we need to drill down into certification is obviously a great option, but we have to also inspire confidence in the certification, in the processes that are being followed, and finally in the eventual kind of guarantee that is being provided. So yeah, I think I'll end by saying that overall we think in the absence of a holistic data protection law, we would be a little bit reluctant to purely rely on certification as a mechanism. Thank you.
Thank you. Oh, now this one's not working. Is it working now? Yes? Okay, excellent. So first of all, thank you all for staying as long as you have. And since you all have stayed, I want to make sure that, oh, this is sort of fading out. Since you all have stayed, I want to make sure we have time for you to ask questions. But in order to lead into that, I wanted to quickly summarize what I heard around the topics of fragmentation and interoperability. And I wanted to frame it from the perspective of three core themes. One is fragmentation and the need for interoperability around enforcement itself. We heard perspectives on the importance of cross-border enforcement when it comes to the APEC cross-border privacy rules system, and we heard challenges around whether or not that's enough. We heard and talked a lot about restrictions on cross-border data flows. I think one of the things that's particularly interesting to me in looking at like why are we even having this conversation in the data protection space, if we compare data protection and privacy to other laws and legal disciplines, we know that cross-border enforcement is an international law is particularly important in almost every domain. But what's different about privacy and data protection, and in particular I'm going to focus in on the data protection component, is the movement of data, the access of data or to data by people all over the world. And I'm going to go back to my own experience in practice before this became as big of an issue as it did. We at my former employer, where I worked for 22 years and led the privacy program there for 12, started focusing on it's not just about each individual country compliance, it's about how we comply as a company because of the restrictions on cross-border data flows. That's when we started thinking about it differently, and we had to worry about, well, is the EU going to recognize the US because we were a US headquartered company? What I have found over the years as things have continued to evolve, and so this was all the way back in 2001 when we first started worrying about it, as things have continued to evolve, it's not only about the cross-border enforcement, if you will, which will continue to matter and has different themes depending on how you're looking at it and through which lens. And not only will we continue to have the challenges around cross-border data flow restrictions and now localization, which creates its own challenges, but as more and more countries and provinces and municipalities within countries are adopting their own laws, which by their very nature, because they're in their own individual jurisdictions, will have the flavor of the culture and the legal system in that country. It will not always be one uniform approach. We have to look at how companies are finding ways, particularly when they're doing business across jurisdictions, to comply with all of those different standards. And for those of you who practice inside companies or advise companies, I think the one thing we haven't spent enough time talking about and would really invite people to the extent we have time to talk a bit about is what does this mean in practice? Because we can have well-designed laws and we can have good cooperation, but in practice for organizations, and particularly those that are not enormous but are still doing business across multiple different jurisdictions, they need to find practical ways of adhering to these different standards. One of the reasons that we as a company, and I was before I came to this company, a proponent of certification, is it helps companies look across different standards and find those commonalities in how they can show that I'm meeting those different requirements. That helps to demonstrate compliance to regulators on the one hand, but internally it goes to the practical effects. Because if a law is too hard to comply with, it actually makes it impossible to do business effectively. And if it's impossible to do business effectively, people are going to find ways to just not comply. We never want that as a result. We want people to comply, so we need to find efficient ways of doing so, and interoperability in practice is one mechanism for doing it. So I would invite the audience and our panelists, but I would like to first invite the audience to really explore any one of those themes, whether it's enforceability, whether it's cross-border data flow, or whether it's in practice, how do I comply with all these different things? And with that, I'll turn it over to you if you have questions, and if you don't, then we'll turn it to the panelists to comment. Any questions in the room? We do. Okay, we have one toward the back.
Thank you. So to really get at a significant problem with interoperability, I'd like to ask, are there cases that you could point to where there is contradictory requirements between different legal systems, so that, let's say, it is inherently impossible for you as a company to be compliant with both the Chinese regime and the European regime, and so if you are a client country, let's say in Africa or in Asia, you face a problem. Are there specific instances where you can really point to these are incompatible requirements in data protection regimes?
Anyone on the panel where you've seen specific incompatibility in data protection regimes themselves? Mac.
So I will try to answer to your question, and including the the moderator's question. In our experience, talking from the Japanese experience to think about the compliance to the GDPR, also the PIPA, Japanese Personal Protection Law. So what happened in each Japanese company is, if we have the database of the personal data, so we might be separate or duplicate two different systems. One is for the Japanese citizens, and second is to the EU citizens. If we want to transfer the EU citizens' data from the EU, so this is some sort of the contradiction, but it's not really. So the difference is only the level of the protection, how we can have the consent from the data subject, or how we can treat the data. Professor Simple has talked about the 6 months requirements of the data retainment, and so something is very different. But we can sort it out by designing the data system, database, by setting some flag. This is a Japanese citizen, and this is a EU citizen. So that is what is not what we can't solve in the designing the systems or database. So this is a very good example, and the difference of the the enforcement of the data protection legislation, it is the basement is the same. Okay, for example, that the OECD guidelines. So maybe we can do something to harmonize and have a good solutions. And what is important is who has the solutions will be the winner in the data economy, digital economy. Okay, thank you.
Anyone else on the panel have a comment on that one? Amba?
Yeah, I don't know if I'd frame it as incompatibility. I think often it is a question of, stricter standards and less strict standards. And often as companies, and I can speak for ourselves, it may make sense if you're operating at global scale to comply with that higher standard, because that immunizes you, like I said, to kind of challenges from new data protection regimes that are cropping up. And I don't necessarily see that as a bad thing.
So I'll comment just based on my own experience. Two things. One is, I think where I have seen the most challenge with respect to interoperability in practice when it comes to different regimes is trying to develop a consent mechanism or a consent form or form of privacy notice. So it's really that transparency and then consent in a way that you can use across jurisdictions. It is incredibly difficult because different laws have different things you need to say. And so typically what we find is there is a core set of things that need to go in every privacy notice and every form of consent. But then that's just your baseline, and then you have to iterate on that across where you actually offer that in each market. So that becomes very hard for companies to be able to manage. Where I would say I've seen the greatest conflict is really not between data protection laws, but rather, as I think we all know, between data protection laws and other laws. And so we'll harken back to about a decade, 15 years ago, where the challenge is about obligations to report, so with the whistleblowing concepts to actually report fraudulent conduct, and other bribery and other things. And that had to be, we had to figure out a way to do that in compliance with privacy and data protection laws here in the EU, and obviously that has spilled over into other countries as well. Bruno?
Yes, I would tend to agree with what Amba in particular has said. We don't see so many incompatibilities. There might be a difference of level of protection on some issues, but we have found ways to address them. Privacy Shield is an excellent example of that, for instance. The main problem, I don't know if we can call it an incompatibility, is what also Amba has mentioned, the tendency of some legislation to use the pretext of data protection. And that's why I don't think that's a data protection incompatibility, to impose localization requirements, for instance. That's something that has nothing to do with data protection, and which is sometimes inserted in some of the laws we've seen, and we have been very clear both in our submission in the Indian to the Indian consultation, but also in our trade policy, where we now systematically in trade negotiation table text containing straightforward prohibitions of data localization or other similar measures. I think that's one of the main challenge and main issue, also, of course, in terms, first of all, of possibility of carrying out data flows.
Question over here.
Hi. Beside the Japanese initiative that you mentioned, there's also the start of e-commerce negotiations by some WTO members. Will data flow issues also be a topic there? And do you expect, so the different sides, do you expect harmonization from there?
Matt, go ahead.
Okay, thank you for the very good question. So basically, yes, the data protection is some issue in the trade negotiation. So, but I know some, for example, Russia is just opposing that there should be some separated discussion for the trade and data protection. So it's not a common sense that we should also talk about the privacy protection in the trade negotiation. So the reason is that the legislation is legislation and the trade is the economic affairs. So I don't know which is better, but there's some diverse thinking about how we can converge these different discussion into one. So, okay.
Yeah, we had that discussion this morning. Actually, if we want to capture privacy is not to be traded in trade negotiations. We are talking about human rights. There are other instruments, and we are all talking here about these different instruments to have data flows and to achieve free data flows. So our position is, as the EU is very clear, you cannot negotiate or think of achieving common standards in terms of privacy in a trade instrument, but the trade instrument can be very useful to address and combat the type of practices I've just described, such as forced data localization. That's typically something that needs to be addressed in a trade instrument. Going to throw something, maybe in our discussion. There is actually an instrument in terms of harmonization at international level and interoperability, which has not yet been mentioned in this discussion, which is Convention 108. With an increasing international membership, I often hear, we would need a convention, we would need an international treaty in the area of privacy. Well, there's one that exists, which used to be a European instrument, but which now is a truly international and universal instrument with increasing membership from Latin America, Africa, and Asia. So that's also maybe an element we should take into account in our discussion.
I just want to note that I agree with Bruno that I don't see the WTO as the most likely place where we're going to have a privacy discussion. You'll have the data flows, data localization for storage. In the Indian privacy law, they require or legislation, I should say, they require a local data protection officer, not just a global data protection officer. So that gets to cross-border trade and services issues. So I think those are conversations you'll have that touch on privacy and touch on these conversations, but not privacy specifically. You see in the United States has negotiated a trade agreement with U.S., Canada, Mexico that includes provisions on privacy and cross-border data flows, yet it still maintains exceptions for certain legitimate public policy objectives. And I think that that's a common standard that you'll see. I, in the morning panel, referred to something along the way we regulate patents and intellectual property on a global level as potential solving point or placeholder for an international agreement around privacy, which is specific to that one concern. In the United States, IP is regulated in our Constitution. So like the fundamental rights of Europe around privacy, it's not something that we are just going to give away in a trade agreement for, rice subsidies or something like that. So it has to be a different conversation when you're getting at something that's a constitutionally protected right. And lastly, I just wanted to talk about, touch on back to, I heard a lot of great points about issues around certifications, bringing around interoperability from my fellow panelists. And I think that Bruna's exactly right, that we need strong enforcement as the foundation. It's one of the reasons the US and Japan have supported the CBPR system. The first thing you need to do is to join the CBPR system is have an independent regulator. You can't join the system without one. The second thing you need to do is that independent regulator needs to agree to work with all the other independent regulators on joint extraterritorial enforcement. If they don't agree to do that, you can't join the CBPR system. The third thing you need to do is take not just say, I'm in company in X country, therefore I comply with X country's law. You have to demonstrate, you go to a certifier, they make you fill out a contract with them and demonstrate, yes, I do all of these things. They review it. It's very similar to the way the Privacy Shield works, where my colleagues at the Department of Commerce review your application and they say, no, you are not in compliance with this. You're not a Privacy Shield company. Then you go back and then they review it again. They say, okay, you're in compliance. You're a Privacy Shield company. And so there have been already under GDPR massive fines and massive enforcement actions against companies who are not in compliance with GDPR. We've seen that. We've seen the Google fine. We've seen other actions taken. In the 6-year history of the CBPR system, there have been exactly 0 cases taken to backstop enforcement authorities. And one of the reasons for that is companies cannot just say, I'm compliant with. They have to prove it, and it has to be checked and rechecked annually. I think that, to me, gets at the 2 most important parts about privacy. One is what is in the interest or the right of the consumer, and then 2, what is the company actually doing with the data when they have it and why? And those are the foundations that laws and regulations can't force compliance with. You can fine, you can do all these things, but you can't force it and you can't go in and check just because you have a law. And I think that the certification itself is very important for that purpose, to make sure there's this cross-border compliance in what you're doing and what you say you're doing, and making sure there's a check that's enforceable. So that's been the United States' position in both our relationship with the European Union under Privacy Shield and our APEC partners under the CBPR certification.
And with that, it is time for us to close. So I want to thank each of the panelists. This has been a lively discussion. Obviously, something we'll continue to talk about for many years to come, but I think we've made a lot of progress. So thank you, everyone. Thank you for staying, and we look forward to future dialogue with you.